Welcome to the Binary Agora. In this series, we dive deep into the world of legal tech, breaking down its challenges, its innovations, and real-world impact with top insights from researchers, practitioners, and also officials. And today, we have the immense pleasure to have with us Verity Egerton-Doyle, who is the person you'd want to call if you were designated with a strategic market status, so an SMS stated by the CMA. She's a partner in Linklaters London Antitrust and Foreign Investment Group. She's also a co-head of Linklaters UK technology sector team and global co-head of the games and interactive entertainment practice. So welcome to the Agora, Verity.
Thank you for having me.
As of the end of October 2025, really the CMA, so the UK's competition authority, confirmed that both Apple and Google have this strategic market status in mobile platforms, and it has already established that Google hold this same position for its general search services. So at the channel, we have really spoken quite a bit about the DMA and how it's all coming along, but we have discussed less about the UK's perspective. These are the first decisions that the CMA has issued, really designating this strategic market status operator. So maybe you could explain what their scope is and what services could the competition authority potentially address by imposing conduct requirements. For the audience, conduct requirements are the equivalent of the obligations that would be applicable to these operators.
A really important thing to mention at the outset, which I know will be clear to people who've listened to your previous recording on the SMS regime, is that the act of designation itself does not create really any new legal obligations or any new rights for third parties. And otherwise, in terms of conduct requirements, there are none until the CMA writes them. We're in a phase where we do have these 3 designation decisions, but as of yet, there are no rules imposed on the relevant businesses. I think your question was, what could the CMA do now that it's made these designations? What it could do is it could impose conduct requirements. All it needs to do to impose conduct requirements is consult on those. And the CMA has indicated that it will consult in the case of Google Search on the first set of conduct requirements still this year. We don't have a date for when the CMA intends to consult on conduct requirements in relation to the mobile platform cases. What conduct requirements can be imposed by the CMA are closely connected to the so-called digital activity that the CMA has defined. In the context of the DMA, you obviously have the core platform service concept, and then the obligations flow from which core platform services are designated. The CMA regime is, as you've discussed previously on the Agora, much more flexible. It is still tied to this concept of a digital activity. If we take, for example, the Google Search designation, the CMA has designated Google's general search and search advertising services, and they set out in the designation decision what is included within that. So general search includes Google search services, so the Discover feed, top stories, news tab, as well as Google's AI products that form what the CMA calls an integral part of Google's general search infrastructure or products. So that includes AI overviews and the AI mode feature on search. In terms of search advertising, it includes Google's ad products when they're engaged in search advertising, so Google Ads, AdSense, Search, SA360, etc. It's also important, though, to flag what's excluded. So excluded from the designation is Google's Gemini AI assistant and the standalone Google News app and Google News website. And search advertising also excludes Google's ad products when they're used for display as opposed to search advertising. That kind of gives you the broad parameter of the set of digital services that the CMA could impose rules in relation to. Its power to impose rules in relation to those services is really very broad. The CMA need only be satisfied that the conduct requirement it proposes to impose is proportionate to achieve one of the objectives of the legislation and is of a permitted type of conduct requirement. But the list of permitted types of conduct requirement is very broad, and with few exceptions, I think it's hard to think of things that the CMA would not be able to do with those powers.
For Apple's and Google's mobile platforms, how did that designation work? So did the CMA really designate based on the operating system or the apps integrated within those mobile platforms?
In both cases, the designation combines each of Google and Apple's mobile operating system, in case both of them include the tablet operating system as well, although obviously the Google system is used across a wider range of devices. It also includes their native app distribution services and the mobile browser and browser engine. It's, again, kind of a relatively broad set of activities, and notably, I think, by contrast to the DMA, it groups together a number of things which, are kind of dealt with separately under the DMA. One of the key things to mention is that whereas under the DMA, the rules flow directly from the CPS designation, at least on paper, the rules as they apply to Google and Apple's mobile, various aspects of their mobile platforms are common. Actually, the CMA's decisions in each case do recognise the really significant differences, and there are clear indications that the interventions that the CMA intends to take in relation to each will be quite different, even when the CMA eventually takes them, probably sometime next year.
Building on those significant differences and bearing in mind that also the CMA considered AI mode and overviews functionalities integrated within Google search, would you say that the way in which the CMA incorporated all of those services really provides us a hint of where its priorities will then move on to in terms of imposing conduct requirements?
The definition of digital activities is certainly very important. I think what gives us more of a sense of where the CMA's priorities are going to be is the roadmap that they've set out. At the time of the provisional decision in each of these cases, the CMA, and this is something that wasn't required by legislation but was written into the guidance, the CMA published an intervention roadmap. In that, they set out the potential interventions they were considering and the rough priority that they would give to those. We have a sense of category 1 interventions, which are likely to be taken first, and category 2, which will likely follow. Then we have interventions that are not deprioritized, but less likely to happen in the short term, as well as interventions where the CMA is kind of adopting a bit of a wait and see approach, which is a concept we've been discussing in a merger context with the CMA, given the strategic steer from the government that the CMA should focus on UK specific issues and ensure as best as possible that we're not kind of diverging without reason in the UK. The CMA is where there's, major ongoing cases abroad, especially in the US, kind of is very clear in its roadmap that it will wait and see what happens in those as it designs any interventions it might choose to take.
On the note of AI, when the DMA is concerned in terms of its enforcement, we see all of these problems relating to how unflexible the CPSs are, in the sense that we don't have a Gen AI service, so that it's really difficult to say this particular provision applies to an AI service. So it's really surprising to see an enforcer of these ex-ante digital regulations coming up and saying we are ready to tackle AI. And I was wondering whether you think that approach is really coherent with that wait and see approach in terms of the economics underlying the development of AI, or we must wait until those markets have grown to a point where we can determine the characteristics and the reasons that justify the application of an ex-ante regulation are given here. What would you say would be the right approach to take there?
I realize I should have said at the beginning, obviously all of the views expressed are my own and don't represent the views of my firm, and certainly not of any of my clients. In relation to AI, I think that's a really good question. I think the CMA has been relatively cautious, at least on paper. As I said, the designation is the starting point. So the designation gives the CMA permission to write conduct requirements, and the other thing they can do is take pro-competition interventions in relation to the designated activities. Although the line between conduct requirements and pro-competition interventions is not crystal clear, I think the idea is that more major interventions might be pursued through a pro-competition intervention, where you have to first establish that there's an adverse effect on competition and the intervention remedies that. Higher legal bar, and there's a longer investigative process than in relation to conduct requirements. But coming back to your question on AI, I think the CMA did look at this very closely. While they have included certain aspects of Google's AI activities, those that, as I said, are an integral part of search, according to the CMA, the mere inclusion of those doesn't necessarily mean that there's going to be any intervention in relation to those. All that does is give the CMA the power to be able to take interventions in future if they want to. I should say the CMA was at pains to note in its decision that during the course of the designation period, as in particular Google's Gemini AI business model develops, it may subsequently fall within the scope of the designation description. I think that's if it becomes more kind of intrinsically linked to search. Under the legislation, that would technically be for Google to continually self-assess which of its products fell within the designation description. But the CMA has committed, in the interest of legal certainty, to carrying out a public consultation before deciding whether to add any of the Gemini AI assistant functionalities or related products into the scope of the designation. That was the subject of, as far as I can see from the public materials, a fair amount of debate during the designation process, and I'm sure there'll continue to be debate there. Obviously, there was debate also over the inclusion of AI overviews and AI mode features, which the CMA did include. Actually, their inclusion as part of search, is in line with Google's public description. While there was some discussion around the right scoping of that, Google did actually accept their inclusion in the decision. The other side of AI is, of course, how AI is changing competition in these markets, which have been perhaps relatively stagnant in terms of market power for some time. And that's obviously certainly the case in search, where Google's held a very high market share over a long period of time. Google argued that actually, AI is a new entry point into search, which presents an emerging and increasing competitive threat to its search business. The CMA found that while it is an emerging threat, there are currently limited alternatives to general search products, and there's still uncertainty about whether they'll disrupt Google's products, and if so, how Google might respond. It's fair to say there's kind of a watching brief there. And certainly these designations are, as you kind of hinted at, they're coming at a moment where AI is changing everything. And I think that all parties and the CMA is right to be very careful about how it deals with that. And the huge change coming with AI does mean that it's right to be a bit more careful about how you design interventions than you might have been if you were thinking about a world pre-AI where things looked certainly not static, because these are very dynamic markets and always were. The scale of change that's coming does mean we might need to reassess some of our priors in terms of, what is it that we're worried about? How entrenched do we think these positions are in these and other markets?
Great difference with how the European Commission approaches regulating all of these markets, especially on the side, and we have already talked about that, on the side of economic evidence. So how the CMA gets to the conclusion that this segment of the market must be captured by regulation and the conduct requirements that may be imposed. I was wondering, how did you perceive the economic evidence and how really the CMA backed up all of its arguments relating to the capturing of these undertakings, now designated with this strategic market status?
One key difference with the DMA somewhat kind of writes economics out, in that its intention is to create clear, supposedly self-executing rules. Obviously, now we're a year and a half in, I think we can all have a debate over how self-executing they really are, given the disputes there have been over compliance. The concept of the DMA was to make these things simpler, in part by taking out the need to have extensive economic evidence as you need to have to bring a successful case under 102. The CMA regime is very different in that it is meant to be much more about individual assessment of the market and of potential interventions, and there's a much greater role, I think, on the face of it for economic evidence in this process. I think where we might see, so you do see use of some economic evidence in the designation decisions, but I think where we might see more of that is when we come to looking at interventions and designing interventions, conduct requirements, but especially pro-competition interventions, where you need to establish an adverse effect on competition to make the intervention. There's a clear role there for detailed economic work. If you look at the evidence that the CMA relied upon in its designation decisions, there is, of course, economic evidence submitted by the parties and by others. I think what's really striking is the number of stakeholders who they engaged with. So, in the search investigation, the CMA had 80 participants who attended roundtables. They had 50 third parties responding to its invitation to comment, and to its proposed 34 responding to the proposed decisions. Really high levels of engagement, even higher levels of engagement in the mobile platforms cases. So they heard from over 150 market participants. And it's quite clear that from the CMA's public announcements, as well as hearing CMA officials discuss how they've approached this regime, that engagement with a broad range of stakeholders, certainly detailed engagement with the proposed designee, has been a really critical part of the process. Of course, the regime is intended to be participative, not just of the firm being designated, but of those who interact with the business. And that engagement, I think, will also be really critical in the next stage as they look to design interventions in a way that, that really works and is targeted, effective, proportionate, rather than something that might be blunt rule on paper, but doesn't actually achieve the objectives of the legislation. The other evidence sources that were very important to the CMA in all three cases, they conducted market research. In the case of search, qualitative consumer research and a consumer survey. They also had a consumer survey in the mobile platforms case, as well as a developer survey where they had about 500 app developers surveyed. That evidence was important to their decisions. The final thing that was also important was the engagement that the CMA had with experts and other regulators. So the CMA has a panel of digital experts who it engages with, but it's also really clear they engaged, as the legislation intends them to, with other regulators. So in the case of search, in particular with Ofcom and the Information Commissioner's Office. In the case of the mobile platforms case, even more regulators were involved. They consulted not just Ofcom and the ICO, but also the Payment Systems Regulator, the Bank of England. They talk about engagement with members of the CMA's own Growth and Investment Council as well as part of that process. The broad engagement is, I think, really critical to this regime. I think all of us hope will lead to targeted, proportionate, effective outcomes.
Moving from these designations and going to the conduct requirements, because I was thinking about compliance and how some of the now designated gatekeepers and in the UK as having strategic market status, they sometimes design their compliance solutions, bearing in mind also the UK. For instance, I'm thinking about portability solutions that are already applicable both in the EU but also in the UK, because some stakeholders really pressured them to extend the scope of their technical implementations of the DMA to other countries. I was wondering, how do you expect the CMA to react to those kinds of iterations with the gatekeepers / SMS operators, in the sense that it may well be the case that the CMA wants to apply the same remedies to the same operators. So what do you expect the CMA to do? We are going to target maybe those segments of the market that have been left unaddressed by other pieces of regulation at the EU level, or is it going to take a hands-on approach in the sense that we want to introduce other legal standards of alternative distribution of apps, for instance, on the iOS environment, vertical interoperability mandates, or self-preferencing prohibitions?
I think the CMA is without a doubt looking very closely at what the rules under the DMA are and how those have been implemented by the relevant firms. I think what the CMA has been pretty clear about is that where they think action that has been taken elsewhere fully addresses issues in the UK, they don't have a great interest in just duplicating that. It's yet to be seen whether any of those obligations would be written into codes of conduct, or if the CMA might even just rely on what's already happening, where they can see that that is effective for UK customers. The CMA has also been clear, however, that that where they think there are UK specific issues, or where there are interventions that have not been rolled to the UK that they'd like to see rolled to the UK, they won't be afraid of taking those interventions. For the most part, you would expect where there are interventions in Europe that the CMA thinks are effective that aren't yet rolled out to the UK, they will seek to roll those to the UK. But I think they'll also, on that question of whether they're effective, I think the CMA will be looking really, really closely at, is there an opportunity to do better than the DMA, to make things clearer, or perhaps to make things even less burdensome for businesses as well, so that it might be that there's a relatively blunt obligation under the DMA. Maybe that can be implemented in a kind of firm-specific way, because remember, these codes are firm-specific, in the UK in a way that is either more effective in terms of delivering outcomes for UK consumers and businesses, less burdensome for the SMS firm, or, ideally both. If you look at the kind of list of interventions that the CMA is considering in Category 1, a lot of these look, quite similar to a number of things that you have under the DMA. In the case of search, for instance, you've got choice screens to allow switching between search services. You've got fair ranking principles, ensuring effective data portability mechanisms for consumers to support competition and innovation, publisher controls to allow more control and a more effective complaints process. Much of that is quite similar to some of the obligations you have under the DMA, but I think in the way that the CMA actually writes the codes of conduct, they'll be looking really closely at exactly what has happened under the DMA. In a way, we have this nice kind of competition between competition regulators in terms of a natural experiment of seeing how different interventions can work and iterating around the world. Of course, from a business perspective, you don't want a complete patchwork of different obligations everywhere. But, if there is an opportunity for the CMA to slightly tweak one of the DMA rules in a way that actually is less burdensome for business but achieves the same or better outcomes, that's something that's positive. And then, you would hope that perhaps eventually other countries would then kind of scale in the same way.
So as I understand what you're saying, so maybe the CMA will take an Australian approach, because the Australians already said within their proposal of a digital regulation that they could bear in mind other compliance solutions that have been proposed in other jurisdictions to translate them into their own jurisdictions. Maybe that would happen at the CMA level. And in those cases, and I was also wondering how the CMA will assess effectiveness. In terms of the final point you were making, it really seems that fragmentation is really coming our way in terms of how these digital operators and digital ecosystems are going to design their own business models. In the EU, we are already seeing that some of these undertakings are already deciding to manufacture their services only for the EU. I was wondering whether you think that the DMCCA will in the end result in an additional version, so a UK version, for instance, of the iOS, or whether you think that a unified approach is more feasible in terms of also coordination and this competition between competition authorities.
I'll start with your last question, actually. We have seen specific versions of all kinds of services now in the EU under the DMA. We've also seen, certain new technologies, new services not being made available in the EU because of concerns about not just compliance with the Digital Markets Act, but also with the Digital Services Act and other legislative instruments. On that latter point, are new technologies being rolled out in the UK? It's the view of certainly of the CMA and of the government that we would want UK consumers and UK users to have access to, the latest innovations in AI and to not be cut off from those as a result of, regulation that is tricky to navigate. My hope is that the way that the CMA implements this regime will facilitate that and won't create hard rules that cut off new technologies coming to the UK, but will be set up in a way where there can be an open discussion between the CMA and the company about, a way to bring those services and products to the UK in a way that is compliant and in a way that is good for consumers to have access to the latest innovations. At the same time, I think that it's a huge range of potential interventions that can be taken under these regimes, right? There are some things that are kind of almost purely contractual. They don't actually require engineering changes. They're just changes to the way that the user agreement works. For those, there you can see that if there's a UK specific issue, maybe you have a UK specific intervention and that might be different to what happens elsewhere. I think that kind of divergence is less problematic because it doesn't require re-engineering, redesign to the same level. You want that intervention to be properly justified and necessary for UK customers, otherwise it's just kind of unnecessary red tape. That kind of intervention, which looks at contractual terms of service in the way that UK customers are dealt with, I think is less problematic than divergence, which leads to fragmentation at a technical level, which means that you potentially don't get access to the latest technologies in the UK.
Wrapping up the episode, aside from all of this public enforcement that the CMA will perform with regards to the DMCCA, I was wondering how private enforcement might unfold, whether you are already seeing some stakeholders moving their pieces in terms of we're going to put forward actions before the courts and claim or reinstate the previous competitive state of things prior to the DMCCA's entering into force, because we are already seeing that stakeholders are really interested in seeking private redress. Sometimes those rulings can contradict the regulator's stance on a particular provision.
It's useful to split that in two and to think about private enforcement of SMS obligations, where you can't have private enforcement of conduct requirements before they're written, but the legislation does allow for private enforcement. I'm sure over time we will see some of that. What the legislation does not allow for is collective proceedings off the back of opt-out collective proceedings of SMS breaches. That creates a more challenging situation for people. I guess it forces them to think a bit more carefully about whether they can get funding for those things in a way that you can where you have an opt-out class action available. That I see as kind of a bit further down the track, where we are seeing already an impact of these regimes on private enforcement is, of course, they are tackling a number of issues that have been dealt with previously under Article 102, Chapter 2 here in the UK, especially in the case of the CMA, which read very well. They read as very, evidence-based. They're usually quite detailed. They're written in English, which makes them very easy for people to pick up and use to support cases in collective proceedings that are actually brought in the UK under Chapter 2 of the Competition Act for abuse of dominance. There is no doubt that funders and class representatives and, claimant side law firms will be actively using all the material that the CMA puts out into the public domain to try and support cases. For now, while we only have class actions for competition breaches, but possibly in the future for other things as well.
Thank you so much, Verity, for your time and for really getting down into the details of these designations and how they are going to impact the conduct requirements. I'm really glad that you could join us here in the Agora and really looking forward to meet soon.
Thanks so much for having me, and thank you for the great discussion. Bye.
Thank you.